You may have seen in the news about those young lads who threw the footrest, or poof as we used to say back in the day, off the balcony in the shopping centre. Now, I'm not going to speak about that specific case because now they have been arrested and I understand they're being charged. And I'll come on to that momentarily when I get back to it, but this is more of a generic thing. But a couple of days ago, we were just chatting among, sort of on law Twitter about this, and I posed the question, what might be the offence, if any? Like I say, this is just generally speaking, so I'm not saying it's in relation to that particular case, but it's quite interesting because we don't really have anything to cover that. I mean, there are some offences and these people have been charged, but generically what might people be looking at? Because part of the problem is, I mean, first of all, some people said, this is clearly attempted murder. And obviously it's very, very dangerous, but you can say straight away, it wouldn't amount to attempted murder. Why is that? Well, as we've said before, when you get into crimes, you have two elements. You have the mens rea, that's the mental element, your state of mind, and the actus reus, sort of, what is the actual, act? What's the sort of physical thing that happened? Well, the physical thing here is something was dropped off a balcony and landed and didn't hit anybody. And it's interesting as to whether or not anything was actually even damaged. But for the attempted red rum, I've already said the M word, so we'll see if this gets demonetised. But for the attempted, red rum offence, first of all, there has to be an act that effectively puts somebody at risk. But the mental state is that you must intend to K-word. Rhymes with will, so there's got to be an intent to actually have that ultimate result. Now, interesting, that's different from general red rum. So in red rum, if somebody ends up shuffling off this mortal coil, the intention there is, yes, it can either be an intention to K-word, or it can just be an intention to inflict serious harm. So the actual mens rea element for attempted M word is actually more strict than for if you actually complete the offence. And intention is, it's something that you as the name says, intend to do. It's not something you're reckless as to whether or not it happens. It's something where you go, yes, I want this to be the outcome, and proving that is very hard. Now, interestingly, there is a case on this, Crown and Hancock and Shankland, which was during the miners' strike. A couple of miners threw a lump of concrete off a motorway bridge. Now, they eventually said it was to scare a taxi driver who was taking miners to work, but the concrete went through the windscreen and took out the guy. So they were prosecuted for the M word and they were duly convicted. But they appealed on the ground that the judge's summing up had been incorrect, because what he'd said there is, just look at the outcome, and from the outcome you can infer whether or not they intended it. And the Court of Appeal said, well, actually no, you need something more than that. You should have directed the jury that it's not just enough that that's the consequence of what they did. You have to show that it was reasonably foreseeable and a logical outcome to their voluntary actions. Now, it may well be that had they explained that to the jury, they'd still got the same result. But in the end, the Court of Appeal downgraded that to manslaughter. The Crown had tried to appeal to the House of Lords on that, and they got knocked back, and they said, well, no, the Court of Appeal have got that right. The judge needs to give a more specific direction. It's not enough that you've merely caused that, you have to have intended that. So I think that'd be a very high hurdle to overcome here, because proving somebody's state of mind in the absence of explicit words, I'm glad I did that, or I'm going to do this, or I'm going to do that, or people say, oh yes, he'd always planned this, or showing that there was some animus that he sort of aiming for somebody he dislikes. It's very, very difficult. So attempted red rum is out of the window. What are the other offences? Well, there could be an assault. Because an assault is, as we've discussed recently, assault is where you do something that puts a person in apprehension of the use of unlawful force. And certainly dropping somebody on something like that on somebody, that would meet the definition of unlawful force. But the interesting thing there is, were people put in that fear, in that apprehension? Because unless actually they were looking up at the time, if it just lands there, then arguably you've not even committed the assault, because they didn't even know they were at risk until it was all over. So arguably, assault is out of the window. Now, in this particular case, these guys have been charged with criminal damage. And we did discuss this, but what's the damage? I mean, this footstool, this footrest thing, was that broken? Was the floor scuffed? I mean, as we've said, criminal damage can be, relatively minor. A scuff would be enough. But you'd first of all have to show that there was criminal damage. But interestingly, under the Criminal Damage Act 1971, a person who without lawful excuse destroys or damages any property belonging to another, intending to destroy or damage such property, or being reckless as to whether such property would be destroyed or damaged, shall be guilty of an offence. But here's the other thing. Under section 2A, a person without lawful excuse destroys or damages property belonging to himself or another, so even if it's your own property, intending to destroy or damage any property, or, and this is the thing, being reckless as to whether any property would be destroyed or damaged, and intending by the destruction or damage to endanger the life of another, or being reckless as to whether the life of another would thereby be endangered, and they shall be guilty of an offence. So let's just break that down. You have to damage something. But it doesn't matter whether you intended to. Recklessness is enough. So if you said, I didn't realise that just throwing something, off of something that high could break it, well, you took a risk, you should have known it. And but then again, it's got to be this subjective recklessness. You've got to have assessed the risk and then disregarded it. You've got to have, been aware that there was a risk. And the trouble with this is, again, if you get people who are just sort of like young idiots, sometimes you can start to say, well, did they actually make that assessment? Because if they just went, as far as we're concerned, there's no risk here, then they can't be reckless as to, carrying out something that caused a risk if they didn't sort of address themselves to that. But then there's the actually putting somebody else at risk as well. So I think that's possibly the nearest analogue to fit this. It might just be, though, that they just have to, if they can't show the intention, it just have to be criminal damage, if something was scuffed or marked. If, however, they can show that people were sort of reckless as to whether serious harm could occur, that's quite a serious offence, and that carries a penalty of up to 10 years. Another offence, though, it's a more recent one, and I think this is why perhaps it wasn't occurring to us. This is under the Police Crime Sentencing and Courts Act 2022. And that's where intentionally or recklessly causing public nuisance. A person commits an offence if the person does an act that creates a risk or causes serious harm to public or a section of the public. So then again, that would seem to be it. They've done something that basically is an act and it put people at risk. And again, that carries up to 10 years. And that's possibly the nearest thing we have in this country to the American concept of reckless endangerment. In the US, they have this idea that you just put people at risk. They have a very similar offence, actually, in Scotland. But we don't really have that here. And I find that interesting because English law is all meant to be about culpability, not consequence. It's why attempted Redrum is an offence. You can't sort of go, well, I missed. I'm such a terrible shot, so no harm, no foul. It's like, well, no. We look at what your culpability is, not what the outcome is. That works both ways as well. That's why there was never an offence of causing death by dangerous driving until quite recently, because they said, well, everybody drives carelessly, and it's completely luck of the draw, usually, whether somebody is hurt by that. I mean, if you're not paying attention and you drive across a zebra crossing, well, if there's nobody on it, no harm, no foul, as I've just said. But if there is somebody on it, then the consequences could be devastating. But it used to be that if you actually caused a death by careless driving, you're only prosecuted for careless driving, and the Crown weren't allowed to allude to the fact that somebody died in case it prejudiced the bench. But because of all the sort of public outcry about that, now we have this specific offence of causing death by dangerous driving. I mean, some people have said, why aren't these things charged as manslaughter? And the simple fact is, when it used to be charged as manslaughter, people wouldn't convict. I think a lot of people on juries are going, there but for the grace of God go I. So they introduced the offence of causing death by dangerous driving. That's where your driving falls far below the standard of expected of a reasonable driver. Careless driving is your driving falls below the standard of a reasonable driver. Oh, some horses, speaking of which. But yeah, so that's where we are now. So realistically, the criminal damage charge is possibly the only realistic charge that you could bring in this sort of situation, and you would actually have to show that there was some damage. I mean, depending on how tough the footstool is and how tough the floor is, even that might be a very hard offence to prove. But then again, like I say, it might well be then that the public nuisance offence is the better one to go with, because like I say, that's the nearest analogue we have in this country to reckless endangerment. And like I say, it's very recent. I mean, the Act was only in 2022. Actually, I didn't even check to see whether that section's come into force yet. And it's really easy to do now because you can just do it online. In the olden days, you had to go into the library, one of the Inns of Court, and look. There was a book called "Is It in Force?" and you had to sort of go through and find the relevant act and then the relevant section, and it would say whether it was in force or not. And that was actually updated daily, but by paper. They would sort of, every time that, you know, Parliament actually initiated an act, because like quite a lot of time they'll pass an act and say this act will come into force upon the relevant Secretary of State saying it will. So that you just get a little bit of a paper memo going, the relevant Secretary of State has now said that act or that section of that act is now in force. But yeah, but there you go. So like I say, very limited options really, and I can see why people were outraged about this, but I'm not going to comment on the case. I mean, the video's all out there, but who knows what fantastic defence they may raise, and currently they are innocent unless and until proven guilty, so I'm not going to say any more about that. But anyway, as always, hope you found that vaguely interesting, vaguely informative, vaguely accurate. I've been tied up, so busy with work. I'm sorry for the dearth of videos, and I've literally, it's quite late by my standards for filming. It's 5:45 now, so I've just run out of work, and I'm going out for a client meeting tonight, albeit in the pub, so that's quite nice. Should at least get a meal out of it. So yeah, I'll try to get more videos up for you. It's just that, thank you clients for all the instructions, I suppose.